welcome to today's webinar. We're going to look at the part 3 of the Good Work Plan, which is looking at fair enforcement. Just to introduce myself, so I am Kelly Games. I'm one of the HR advisors for Code, and I've been working for the company since July last year, and I've worked in various different sectors within the HR departments. So we're going to look at the aims and objectives today of the Good Work Plan. So we're going to look at increasing the understanding of the changes to employment law that the government and the Good Work Plan will introduce with a focus on fair enforcement. So the objectives today are to discuss an overview of employee rights relating to the Good Work Plan. We are also going to look to highlight the risk of failing to follow that employment law. We're also going to look at exploring how Code Total HR and provides essential policies and template letters to help practices comply with their legal obligations. So, the learning outcomes from today. So we're going to improve the understanding of changes to the employment law being brought into effect by the Good Work Plan. We're going to understand the statutory employment law rights. And we're going to avoid potentially costly mistakes relating to employment law. So the session content today is we're going to have a recap on the Taylor Review. We're going to look at the main areas of reform, penalty notices, naming and shaming, statutory pay increases, parental bereavement, and how you can start preparing for the Good Work Plan. There will be a little Q&A session at the end should you have any questions to do with the Good Work Plan or any general HR issues. So just to recap, we are going to look at Matthew Taylor. So the gentleman was introduced into looking at the employment law and the legislation and how we can look to change that. So he did a review of the modern working practices. And the reasons for this, it was the first of its kind, and the world of work has changed since the last review of employment law was looked at. And the things that have changed, so there's a lot more women that are now working ever than before in the UK, flexible working, mental health awareness, social corporate responsibility, and various other reasons for this. And he's looking at making it fairer for employers, employees and workers. So these changes are being brought into effect in April 2020. Some changes were made last April. He did propose 53 changes, and 51 of these will be implemented this year. They will have a big impact. We are only going to look at a few of those changes because it will take quite a long time to go through the 51 changes, but we've stripped back to make sure it's only relevant to you within the practices. So the main areas of reform: fair and decent work, clarity for employers and workers, and fair enforcement, which is what we're going to look at discussing today. I am going to recap on the first 2 webinars just in case you missed those, but you can see our webinars 1 and 2 on the website and they are available to watch as well. So the enforcement process. Recommendation number 22. So employer has breached rights and the resolution to resolve this matter in the workplace has failed. And at the moment, if an employee hasn't received their compensation from their employer, the enforcement process is quite complex. So the government are looking to make this process simpler, so the employees can take enforcement action. So at the moment, there is more paperwork, more fees, and additional court proceedings, and the government are looking to take that away. Naming and shaming. So recommendation number 23. A naming and shaming scheme is being introduced, and this information will be available to the public. Unfortunately, we don't know what that will look like at the moment. We imagine it will be an offenders list on the government website. So this can affect the practice reputation. So this could include recruitment. So when you look to recruit, employees will not want to work for a practice that are on the offenders list, and it also it would inflict on the patients that come into the practice as well. And this is being introduced for those employers who do not pay their compensation awards. So repeated breaches. So recommendation number 24. So this is punishing those employers who believe they can ignore the law. So originally, this came into force in 2014. The tribunal have the power to order employees to pay a financial penalty. Now this is going to be paid to the Secretary of State. And the Good Work Plan increases penalty and the fees in 2019. So this is one of the recommendations that were brought in early. So the fees were increased from £5,000 to £20,000. So a repeated breach, for instance, if an employee takes you to tribunal and then another employee takes you to tribunal and those facts are comparable, so they're similar claims, this would be a reason for an additional fee to the Secretary of State. So various different compensation. So recommendation number 25. So tribunals to award uplifts in compensation. So again, looking at repeated breaches. So payments will be made to those employees. So tribunals might take into account the size of the employer, the duration of the breach, and the behaviour of both employer and employee. What we'd recommend though is that before you even go into this, that you just make sure you review your policies and procedures and make sure your employees are aware of the policies and procedures in the practice. If you have repeated breaches, the compensation could be uplifted by 50%. So penalty and compensation. So at the moment, a payment has to be made within 28 days of a court hearing. So for instance, if you are taken to an employment tribunal, you have 28 days in which to pay that fee that court has ordered to the employee. And as discussed, a 50% additional uplift in that compensation would be made to that employee. And in a previous slide, we mentioned that the process for them to receive that compensation is now a lot easier. This also is additional penalties for the repeated breaches. So there would be additional court fees that go to the Secretary of State, which could be up to £20,000. If employers do not follow their policies or procedures, again, increased compensatory awards of up to 25% can be made. I know our members probably get tired of us saying about following policy and procedure, but because of this, the reasons for the compensatory awards could be a lot higher if you don't follow those procedures in the practice. So just to run through some of the key changes to fairer enforcement. So as discussed, the process will become much simpler for those employees to receive their unpaid compensatory awards. So what we'd recommend is that if there is any HR issues within your practice, that you just get the expert HR advice that you need. It also prevents any employers from repeatedly ignoring their responsibilities, so the employees know that their rights are available. And the financial penalties are increased. So as discussed, there are quite a lot of penalties that have been increased and will be enforced in April. We don't know what they'll look like at the moment and what those increases may be for some, but we know that they are quite substantial. So as I've discussed, I was going to go through the key changes to Part 1 and Part 2 of the Good Work Plan. Also, those webinars are available. So even though if I haven't gone through everything that you need to know about the key changes to the Part 1 and Part 2 of the Good Work Plan, you can view those webinars on our website. So, fair and decent work. The right to request a more stable contract. So, if an employee has more than 26 weeks of service with you as an employer, they do have the right to request a more stable contract. And this can be days or hours. If they're working the same hours or days each week, they can request those for a more stable contract. So a continuous service. At the moment, if an employee has their contract terminated and they're not within the practice or they're with their employer for over a week, that continuous service is broken. This is now being increased to 4 weeks. So agency workers now have more rights. So there is a contract called the Swedish derogation, which is what agency workers usually put their agency employees on. That's now being taken away because it does usually make the agency workers more financially worse off. With a consultation within a company, if requested, needs 15% of the workforce to make a decision. And this is now being decreased down to 2%. So some of the summary of key changes to clarity for workers and employers. So employment status. This is quite important for dental practices as you're aware, a lot of dental practices have self-employed team members. Just making sure that you have the contracts in place to reflect that they are self-employed, and the way that you treat them in your practice is a self-employed team member, and that you have those policies and procedures in place for your self-employed team members. Written statement of particulars, or a contract. This now needs to be a day one right. So when they start their employment, they will need to have their written statement of particulars or their contract available to them to sign. We do recommend that you send them out prior to their employment to ensure that they're happy with the terms and conditions that they're signing up to. Rights for agency workers. So when an agency worker starts work with you, they are entitled to a key facts page. So this will indicate the pay they're on, the type of contract they're on, and the deductions that are being made from their pay, and what that will look like after those deductions are made from their pay. So holiday pay, this is more for casual workers and 0 hours workers. At the moment, their holiday is being worked out over an average of 12 weeks. This is now being increased to 52 weeks. So the risks that are being brought with the Good Work Plan. Well, the government are taking the legislation very seriously, and any breaches to employee rights could be taken to an employment tribunal. Obviously, employees will know their rights and they can raise a grievance should you breach those rights. And with that brings a drop in morale within the practice. That could be any company as well. And we just make sure that if there's a drop in morale, that you try and keep that uplifted. Obviously, they do have the right to raise a grievance, and we just try and resolve that within the practice, but we just recommend that you get that HR advice should that happen. This could also affect the patient experience. So patients will know whether your employees are unhappy, and this then could affect the practice reputation. So the customer care isn't there. And with this is cost. So this will all come down to cost. Employment tribunals can be incredibly costly for an employer. Employees now don't have to pay those fees to go to a tribunal. Recruitment is also quite costly. Again, if you lose patients through the patient experience, that could also cost you quite a lot of money. So how you start preparing for the Good Work Plan? If you have a review of your contracts, so comparing to any changes to legislation, you don't necessarily have to rewrite your contracts. Just make sure that any legislation changes that are being introduced into April, you can compare them with the contracts that you've got in place for your employees at the moment, and you can implement any changes for that. And just reviewing your policies and procedures. So making sure again that they're in line with any policy and procedures being changed. There is a bereavement leave being introduced, which I'll go through in a minute, and just making sure you have those policies available for your staff members. And the employment status. So again, quite big for the dental industry, as you have a lot of self-employed team members. Just ensuring that you have the correct contracts in place for your self-employed team members, and that you treat them like self-employed team members too. Ensuring that you check out our webinars on 1 and 2. They are available on the website to view, and we recommend just recapping with them. And you can also call our helpline should you need any advice, or whether you have any questions about the Good Work Plan. So there is going to be some statutory pay increases in April to the national minimum wage and the national living wage. So as of April, the national living wage to anybody 25 and over, it will increase from £8.21 to £8.72. And anybody at the age of 21 to 24 will increase from £7.70 to £8.20. Anybody aged between 18 to 20, it will increase from £6.15 to £6.45. Anybody under the age of 18 will increase from £4.35 to £4.55. And the apprentice wage will increase from £3.90 to £4.15. So the other statutory payment increases, so maternity, paternity, adoptions, pay rates will increase from £148.68 to £151.20. Sick pay will increase from £94.25 to £95.85. Now we just recommend that you make these changes to your payroll. This again could lead to a tribunal should you breach your employees' rights. As I've discussed, they are introducing a parental bereavement leave in April. Unfortunately, bereavement is something that does affect us all at some stage in our life, and currently there is no obligation for employers to provide that paid time off. We do believe that this will be something that's the start of other bereavement leaves, not just for parents, but maybe for people that lose their parents or siblings and close family members, to give them that time to grieve. 7,600 babies, children and young people under 18 died in 2017, and they were given the reasonable time off, which was introduced in the Employment Rights Act in 1996, and that is their legal obligation to provide that reasonable time off. This is going to be set to change, where they will have paid time off, and that's called Jack's Law. So the reason the parental bereavement leave has been introduced, a young mother lost her 2-year-old son, and her partner was only able to take 3 days of compassionate leave off from work. And one of those days was for the funeral. So she spent the last 10 years campaigning for a better parental bereavement leave. So who's entitled to this parental bereavement leave? Well, anybody with a parental responsibility. So should that be them as a parent, a guardian, adopter, or foster parent? Anybody genuinely with a responsibility of a young adult. Pregnancy. So this will also include anybody that loses a child during pregnancy over 24 weeks of pregnancy. And they will also be entitled to 52 weeks maternity leave. That employee must have 26 weeks of continuous employment to be entitled to the 2-week statutory paid leave. Should they have under 26 weeks of continuous employment, they will be entitled to the 2 weeks statutory leave, and they will not be paid for that. If you do have other enhanced holiday, sick pay and or bereavement leave, if that's what you want to introduce, then we can look at bespoking those leave policies. So here's just a list of some of our key policies and templates that are available on iComply. These are some of the employed contracts. We do have a bank of self-employed contracts, locum agreements, cleaner agreements. And if you do need help, there are guidance documents on iComply for you to use. You can use us on the helpline, so should you need any support with your contracts or whether you don't understand any of the contract clauses, you can call us for that support. If you're part of the Total HR service, we can write those contracts for you. And if you do need any further guidance on how to implement them, we are there available on the helpline. Some other key policies and templates, so the disciplinary procedure, the grievance procedure, the capability policy and procedure, the sickness absence policy, the return to work interview form, the appraisal overview, the staff satisfaction survey, and then the guidance. We have those available on iComply, and we just recommend that you implement those into your practices. As I've discussed in previous slides, having those procedures and policies in place and making sure you follow them will avoid any tribunal claims. We can guide you through any of those procedures as well. So should you need any help with a HR issue within your practice, we are available on the helpline. If you're part of the Total HR service, we can write those letters for you to invite them to disciplinary hearings, grievance meetings, and whether you are implementing the capability procedure. The sickness policy as well, should you be going through that with a team member, we can help you with that, and especially with the hot topic at the moment, the coronavirus. And as discussed, that is quite a hot topic at the moment, and we've had so many calls on the helpline about the coronavirus and how you're managing staff around that. So staff travelling to an infected country, you can't stop your staff travelling to an infected country. When they return from their holiday or their trip, unless they are showing flu-like symptoms, we recommend that they return to work as normal. If they do have flu-like symptoms, they need to call the NHS 111 helpline to find out what their next steps will be. So the sickness absence policy will apply. So whether you have an enhanced one within the practice, the sickness policy will apply within your practice. And this does include self-isolation. So whether the NHS have ordered for that particular person to self-isolate because they may be infected, the sickness absence policy will apply. But please see the government website and the NHS website for any lockdown countries and any further guidance for primary care providers. So the main questions we've had on the coronavirus in regards to managing staff within your practice. Can we have a coronavirus policy and procedure? We recommend not implementing one. The reason for this is it's updating and changing every day, so we just make sure that you keep up to date with the government and NHS recommendations. Can we change our enhanced sickness policy in case our whole team become infected? We wouldn't recommend, again, that you change any policies. It should be through a consultation process. That would be the fair way to go about it. And if you do need any guidance on this, obviously we're available online on the helpline or over email to guide you through this. Through the consultation period. And if you're part of the Total HR service, again, we can bespoke those letters to invite your employees to those meetings. So the differences of pay. So if you're forcing your employee, to stay off, so it's the employer's decision to have that employee stay off work, you would be obligated to pay them in full. If they've been advised by the NHS to self-isolate, the sickness policy will apply. And if that employee is choosing to self-isolate, then they would not be paid. So they have been tested negative for the coronavirus but have choosing to stay off of work, it will be unpaid leave, or if they choose to take holiday pay. And if they take time off for dependents, so for example, if one of their dependents becomes ill due to the coronavirus, the same policy will apply, so they will be unpaid for that time off, or they can choose to take their holiday. So with our Total HR and Employment Law service, with any massive changes to employment law, it's quite good to have that HR advice over the phone or over email. So we can support you with the setup of the staff handbook and any contracts for your practice. So that includes employed and self-employed team members. We can do an annual contracts and HR document audit. So we can check to see whether your contracts and your documents are in line with any changes to legislation. We also have available a web application to manage your staff and then store any documents. So this can help store in with sickness absence and holiday. You would have unlimited access to your Code HR advisor with editing support. So obviously it would either be myself or one of my team members that you'd have as your own HR advisor, and we'd be able to help you with any editing support, so for letters or contracts. So you can arrange a free HR health check or a bespoke quote. The details are on the screen and you can book your free demo. So the upcoming events will be at the Digital Dentistry Show on the 7th of March in London. We'll be at the Managing Mental Health in the Workplace on the 10th of March in London. And we'll be at the North of England Dentistry Show on the 28th of March in Manchester. We'll also be hosting a HR workshop on the 5th of June in London. We haven't got any details about that at the moment, but once we know, we'll release them and hopefully you can join us. So the webinars, as I've suggested, I would recommend watching 1 and 2 of the Good Work Plan to make sure you're up to date with any of the legislation changes and whether you need to make any amendments to your contracts, your templates and your policies and procedures. And the next webinar will be on the 9th of April with my colleague Alex, and the topic he'll cover is how to audit effectively. So I've had a lot of questions in regards to the part 1 and part 2 of the Good Work Plan. So me and my colleagues put together a few of the most frequently asked questions, just in case you had them to ask today. So who has the right to request a more stable contract? As I've discussed, is anybody over the 26 weeks of service can request a more stable contract within your practice. And do I have to accept those requests? You have 3 months in which to make that decision, and you'd have to have a very good business reason why you wouldn't accept that request. So the changes to agency workers' rights, and what does that mean for me? We're not quite sure yet how that'll look. We imagine the fees will be increased. If my employee resigns and they want to return within 4 weeks, do we have to honour the continuous service? No, you don't have to honour the continuous service. That employee has chosen to resign and therefore they will not have the continuous service.